Good morning. My name is Peter Singleton. I was very pleased to be asked to chair this session. I'm not necessarily sure quite why, given the range of people in the room, but I presume it's because of my connection with electronic health records. From a startup in Cambridge about 15 years ago through to the dreaded national programme, but also through my affiliation with UCL with a number of European projects, and probably most recently the EHR4CR, the Electronic Health Records for Clinical Research, which is attempting to actually bring together data out of a whole range of institutions across Europe to support the process of initiating clinical trials, not the clinical trials themselves so much, but at least initiating things there, where I was chair of the ethics board. So I suppose in part that's my claim to fame here. One of the things I would like to mention as well was through the Judge Business School in Cambridge, we did a number of informed patient reports back in 2003, 2004, which I certainly found it interesting, following on from the previous topic, about the involvement of patients in healthcare generally. So I have a sort of number of strings to my bow, perhaps. I was also very pleased to ask to chair this one because really, as a chair, I have very little to do because I have two very well-known speakers who need no introduction, partly because they've spoken here before, but also they're so well known. They've done enough presentations that I'm sure they'll be very timely. So given we're starting even ahead of schedule, I hope we can keep that process. One of the things I should mention is Cathy Sugden can't unfortunately come and talk, but Sir Rory Collins has agreed to speak on her behalf. Or, sorry, rather on behalf of the UK Biobank. But Graeme, if you're happy to kick us off.
So I will definitely try to keep to my 12 minutes. My remit for these 12 minutes is as follows: to try and provide an overview of the regulatory context in which data linkage might occur for initiatives such as UK Biobank. So two things I'm not going to do in my 12 minutes are, first of all, talk about samples and tissue. Sean mentioned yesterday the situation of research tissue banks and the way that that's regulated. That may come up, but I can't cover that. And equally, I'm not going to talk about data protection regulation in its draft because that's complicated. It might come up again in discussion, but I can't cover it. I'm focusing on what's currently the situation in the UK and also where we might be going and some ideas towards that, and highlighting some legal and ethical issues arising from the patchwork. And what I am going to focus on is the challenges that arise not just within the health sector, but also the fact that UK Biobank is about promoting health-related research. So that is deliberately a very wide remit, and therefore we go beyond the health sector into other areas such as work and pensions, tax, employment, etc. And Rory mentioned last night that UK Biobank hasn't had a chance to go into those sectors yet. What I would like to highlight are perhaps some of the challenges that UK Biobank and others might face when they try to make linkages within those sectors. I thought what I might do to try and frame the discussion is just to highlight two initiatives that are ongoing at the moment. One focusing very much on health data and one on administrative data. So the first is the FAR Institute. I'm involved in both of these from the point of view of information governance. The FAR Institute is supported by 10 funders, including Wellcome and MRC, and its aim is to try and bring together learning that's been happening around the United Kingdom with respect to data linkage of health data, and try to sort of optimize that at a UK, European and international level. It's very much trying to sort of, if you like, come up with best practices with respect to health linkages. And the Admin Data Research Network has 4 centres around the UK, which is trying to do effectively the same thing with administrative data, whether that be work and pensions, employment, education, etc. So these two initiatives are going on in parallel, and my role in both of them is to kind of sort of speculate as to what the legal and ethical challenges are. So I thought that might be quite interesting as an anchor for the discussion. It seems to me that one of the challenges we really face in this area is to deal with the cultures around and the attitudes around data sharing, towards data sharing or non-sharing. So if you look in the health context at the reports from the Academy of Medical Sciences in 2006 and 2011, I think Rory was involved in the latter of them, they lamented the culture of caution around data sharing with respect to linkages for research. They pointed out the fact that actually there seems to be an absence of proportionate governance with respect to data linkage in these particular sectors. And they also pointed out that actually often what is perceived to be a hurdle in the sector is not actually a legal hurdle, it's actually more an attitudinal hurdle. And actually what they argued for in both those reports is an attitude which takes account of the flexibilities of law rather than seeing law as something that's necessarily a problem. More recently, we've seen the Caldecott 2 review from 2013, which is to dealing with Caldecott Guardians that were set up in 1997 within at the UK. Their remit is very much to look at the protection of patient confidentiality, and there are set principles that they have adhered to since 1997. But the Caldecott 2 review pointed out that there's an additional principle that also needs to be adhered to, which is reminding us that the duty to share information can be as important as the duty to protect patient confidentiality, because there was a concern that there was this culture of caution was also being permeated through the activities of Caldecott. More recently still, we have the CARE Act 2014, which I think in section 111, it makes an incredibly interesting statement for us, which points out that the Health Research Authority and a number of other regulatory bodies, I think it's 8 or 9 of them, must have regard to both the need to protect participants with respect to health and social care research, but also at the same time, the need to promote the interest of the participants by facilitating, the conduct of such research. It seems to me at the moment we have no real obvious method whatsoever as to how to address that challenge. I'd be very interested to hear a colleague from the HRA as to what you're doing about that. But there have been some reactions already that may actually set up a conflict of interest for a regulatory body trying to do both of those things at the same time. But that is an embodiment in law of a commitment both to protect and to promote. And that, I think, is fascinating. But then we have what's happened more recently in England with care.data. I don't want to fetishize this problem. The reason I'm actually raising it is because when Adrienne sort of put out her call to participants here for issues of interest, care.data came up. The points I want to make, however, are the following. First of all, we have to remember that care.data is perfectly lawful under the Health and Social Care Act. The fact that you legislate does not necessarily mean that it's actually okay in terms of publics or other responses. You've got issues about the fact that leaflets were sent out, but they weren't necessarily specific enough. And there was a lot of uncertainty there about what uses were going to be used of people's data being seemingly sucked up into this central warehouse framework, and also the role of commercial interests having access to it. Myself and other colleagues in Leicester University, Pamela Carter and Mary Dixon Woods, have put together an article recently, which we hope is going to come out next year, which tries to argue that one of the reasons why we run into such problems with care.data was a failure to secure what we call social license. The idea that it's not enough just to imagine that because we have a public health system within the UK, you can therefore borrow legitimacy into certain types of initiatives such as care.data without actually adverting to the kinds of concerns that arose. Particularly, you also have to engage various stakeholders, and particularly in the context of care.data, general practitioners, and ask the questions around what are they being asked to do in initiatives such as care.data, because a lot of the concern was actually driven by that particular constituency. And also, it raises fundamental questions about whether something like care.data actually is a public good. What are the reasons, the express reasons, that we can actually put forward as reasonable to suggest that it actually is something that is in the public interest and delivers public good? So all of that speaks to, I think, the idea that I think we need to engage with cultures of caution around this area. And you're going to get different cultures in different sectors. So arguably, we've come a long way in the health context, but I think what Rory might face looking at local authorities, work and pensions, education, etc., are different cultures that may have different attitudes towards linking it and sharing. We've recently put together a report that's available on SSRN about the admin data linkage challenges. And we've suggested that there are 4 types of problem that we might ask of any particular sector. What's actually going on? So we might ask, are we being asked to do something that's simply unlawful? Now, in the vast majority of cases, the answer is probably no. It's probably perfectly lawful to share data, but in an admin context for education or local authorities, they will have specific statutory frameworks within which they operate. So often what you see in those sectors are actors within the sector saying, well, where does it say in law that I can do this? And the answer often is, well, it doesn't. It doesn't tell you you can do it, but the fact that it's silent means that you probably can, but the caution means that you probably won't. So there's an issue there about whether or not there's a question about law. Secondly, there's a question about the ethics of it. I probably can do it lawfully, but should I do it? And care.data is an interesting example of that, and we can discuss what those ethical engagements might look like. Then I think there's also the issue about regulatory burden. How many approvals would you have to get, something like UK Biobank, in order to do the kind of work that they want to do? So in Scotland, for example, we have 32 local authorities. We have 14 health boards. Do you have to go around every single one? And the answer traditionally has been, yes, you do, actually. And I don't even know what the situation is in England. But so what do we do about regulatory burden? And finally, there's notions of this institutional caution, which may be something that's more ingrained and harder to uncover about what's actually reluctant or driving a reluctance to share or link data. And I think an issue there is, particularly in the context of the non-health sector, are concerns about the quality of the data that you're being asked to share. That often institutions will say, well, we're not sure about the quality and therefore we're not sure we want to give you access. Very briefly, in terms of legal and ethical issues, there's a dichotomy that has sort of driven the culture of caution in the UK. This idea that either you get consent from individuals or you anonymise their data. And various people, Roger and others, have written about this, suggesting that, or pointing out that in law, consent, certainly in data protection law, consent is neither necessary nor sufficient to discharge your obligations under data protection. You can find other bases for sharing and linking data. You don't need to get consent. And anonymization is not a technical solution, it's not an ethical solution, it's more a technical solution, although as Peter pointed out to me last night, it's not even a solution. And we might want to discuss that, and Bill's written extensively on that point. I would like to suggest there's also a third branch of governance that we need to be considering here, which is the notion of authorization. So in England, we have the Confidentiality Advisory Group that operates now under the Health Research Authority. It doesn't authorize in a technical sense in terms of saying, yes, you can or not do it, it advises. But there's this idea that we have bodies that actually look at the issues and debate the concerns and then advise the actual decision makers, which in the context of privacy or data would be data controllers, about what should happen. We've got similar mechanisms in Scotland. The Privacy Advisory Committee does something similar. The question there, I think, is what's the social license for those type of authorization bodies? If we take anything from the care.data example, what is the legitimacy that they have in order to sort of exercise some sort of control or authority over what actually happens? And I think there's some salutary lessons to be learned. Finally, Bartek Kanopoulos and I are involved in a report at the moment that's being prepared by the Council of the Canadian Academies looking at data linkage in health and social care across the Canadian provinces. And their approach is focusing on best practices, identifying what might count as best practices. And what's interesting is they've identified 6, 3 from Canada and 3 internationally, and 2 of them come from the UK. One is the work that's been going on in Wales in terms of developing a safe haven, and we can talk more about that in due course, but that's seen as being a paradigm example of how you might actually create safe environments for data linkage. But again, that doesn't necessarily work in all contexts. And the other one is what we've done in Scotland about trying to get these 14 health boards to work together and share data for health research. And what we came up with is what we call a principled proportionate governance mechanism, whereby you don't necessarily have to go around all 14. There are ways in which you can actually deliver what we think is robust governance, but also in a principled way, and I can say more about that. Key to all of this, I think, is robust stakeholder engagement, identifying who are the stakeholders in all of this. So in Scotland, for example, we engaged very actively with the research communities that actually wanted to link the research. What are the sorts of challenges that they face? What are the things that they want? What are the perceived concerns? And we designed the governance framework accordingly, and publics are also part of that. I thought it was interesting this morning, the discussion about public interest of UK Biobank. What I didn't hear being said was who has ownership for that between the UK Biobank and the Ethics and Governance Council in terms of telling the story of what public interest actually looks like. We can't say right now at the early stages of access what it will look like, but when the question is asked, what will the story be? Finally, my point here is I think in terms of good governance, what we need to see is consent, de-identification, I would use that expression rather than anonymization, and authorization working in tandem. So authorizing bodies often can say, no, actually, you need to go back and get consent. Don't imagine that it's one or the other or the other. They actually can work in different fashions, and I think we need to be more imaginative about how that works. So finally, my conclusions are, there's no magic bullet in terms of what good governance looks like. I think it does have to be a variety of approaches. I think taking a principled approach to responsible data linkage is really important across sectors, because although we've come very, very far in the health context, linking beyond that is going to be a particular challenge for UK Biobank and others. And identifying the key principles that will drive this is an important way to start conversations within these sectors about what needs to be considered. Proportionality must be there, but also identification of good practices. And finally, the idea of engagement of all stakeholders, I think, is absolutely key. Thank you.